Welcome to the Digital Planning Podcast. This series is designed to educate individuals about all things digital in connection with estate planning, business planning, and estate and trust administration. To keep up with all things digital, please subscribe to iTunes, Stitcher, Google Play, Spotify, or wherever you download your podcasts. And now, Jennifer Zegel, a partner at Kleinbard LLC, Ross Bruch, a principal at Estate Genie, and Justin Brown, a partner at Ballard Spahr LLP, with today's topic.
Welcome to the Digital Planning Podcast. I'm Justin, and I'm here today with my co-hosts, Ross and Jen. And today we are so happy to have two titans in the estates world, Suzanne Brown-Walsh and Professor Gerry Beyer, to talk to us about the Uniform Electronic Estate Planning Documents Act, or UEEPDA. Susie is a partner at Murtha Cullina in Hartford, Connecticut. She's a fellow in the American College of Trust and Estates Council, and she was the chair of the committee of the Uniform Law Commission that created UEEPDA. Gerry Beyer is the Governor Preston E. Smith Regents Professor of Law at the Texas Tech School of Law. He's also an ACTEC Fellow, and he joined Susie on the Uniform Law Commission committee that drafted UEEPDA. Susie, Gerry, welcome to the Digital Planning Podcast.
Thank you.
Thank you.
So before we go into UEEPDA, Susie, can you talk to us a little bit about the role of the Uniform Law Commission and why the creation of uniform laws is so important?
Sure, I'd love to do that. So for those who are not familiar with it, the ULC is a national, nonpartisan organization. It's been in existence for 130 years. Its members are all lawyers, and that is the sole requirement. Obviously, some are also judges, legislative staff, etc. They're appointed by their respective state governments in various ways. And we also have members from the District of Columbia, Puerto Rico, and the U.S. Virgin Islands. The purpose is we have a scope committee that decides what projects would be appropriate for the ULC. There are criteria for that: interest in the subject matter, prospects for enactment, not terribly controversial because that would obviously negate enactment. And so this is a perfect example of a subject area where the ULC adds a lot of value. We were able to create this law in a year. Usually the drafting cycle is 2 years. And it's a product of the input of commissioners from all of the jurisdictions, practitioners all over the country. And so it's not just commissioners who participate in the process, it's anyone. Anyone who has expertise in a subject area who wants to be an observer is welcome to attend our meetings and provide us with input. So we do what would be, I think, unaffordable if it had to be replicated in a private setting, because everyone's a volunteer and the costs are borne. The cost for the meetings themselves is borne by the ULC.
Thank you for that explanation. For those of our viewers who didn't know, UEEPDA was finalized in July of 2022. And the goal of UEEPDA is to provide a framework for states to adopt a uniform law that permits the electronic execution of non-testamentary estate planning documents. Now, we're going to go into a little bit about what that means. But Susie, can you tell us a little bit about the basis for creating UEEPDA and why the ULC believed that this project was so important?
Sure. This really flows out of a prior drafting project, that of the Uniform Electronic Wills Act. While we were framing the Uniform Electronic Wills Act and determining how wide its scope should be, we determined that all of the other documents that our clients sign, trust, powers of attorney, and the like, the ones covered by this act, we thought they were all allowed under UEEPDA, which is the Uniform Electronic Transactions Act. That turned out to be not the case. There's some doubt about that. So Gerry and I talked to the ULC leadership, and we made a case against this drafting project. We said, why don't we just go ahead and amend the Uniform Electronic Transactions Act? Gerry can explain a little bit more about why ultimately we decided that UEEPDA didn't facilitate the signing of these other non-testamentary estate planning documents. But the bottom line is, the project is very important because there are a lot of practitioners who we all use DocuSign, right, in our practices in some manner. And I think a lot of people, your go-to is DocuSign, and you naturally think, I'll just send that to the client to be electronically signed. And the purpose of this project was to make sure those documents will be validated just as other documents that are e-signed are validated.
Thank you for that background. As we all know, COVID really, really accelerated the discussion of executing estate planning documents through electronic mediums. And, while there's some that believe that the Uniform Electronic Transactions Act already permits the execution of certain electronic estate planning documents that are not wills, there are many believe that the comments in the Uniform Electronic Transactions Act that pertain to the unilateral nature of those documents should prohibit the electronic execution of those documents. So there's a divergence amongst practitioners on whether there are appropriate provisions that allow it, and then some that really believe that they're disallowed. What are your opinion? And Gerry, what do you think about this?
Well, when you look at the Uniform Electronic Transactions Act, it says that it deals with transactions, and transactions require two people to be interfacing, and most estate planning documents are unilateral. So I thought, as did many others, that although it is debatable, there is definite authority or definite strong arguments that the Uniform Electronic Transactions Act would not apply to unilateral documents. That type of uncertainty is not acceptable for attorneys who practice law to know, well, maybe it works or maybe it doesn't work. That's not good for a practitioner. And so it's clear that attorneys desire the convenience of being able to handle these documents electronically, so we decided that something needed to be done. The first thing I thought about, as did others, is, all we have to do is make about a 1 or 2 sentence change to UEEPDA, let it apply to unilateral documents, and we'll be good to go. And that idea, that didn't work because there would be lack of uniformity if some states adopted the amendment and others did not. Plus, there is a very important interface with the federal e-sign laws. And if we disrupted UEEPDA, that interface might be lost. So the best thing to do was to create a separate act, yes, formulated on the same type of structure as UEEPDA, but designed instead for unilateral estate planning documents.
So with that, let's dive into some of the specifics of UEEPDA. As Jen said a moment ago, UEEPDA only applies to non-testamentary estate planning documents. Can you define what we mean by that?
Yes. Well, this is an interesting discussion to have, actually, because we had to discuss and had to figure out how to define what these types of documents were. The first approach we came up with was to come up with a laundry list of documents that would be designated as non-testamentary estate planning documents that the Act would apply to. That got to be kind of cumbersome trying to list everything. So then we switched to trying to have a broad definition, a capacious definition that we could use to define what the documents would be. But after we worked on that definition, we discovered that that didn't work either. And so we went back to a laundry list. So the laundry list in the statute covers things like trusts and related trust documents, financial powers of attorney, advance directives and similar health documents, powers of appointment, guardian declarations, disclaimers, body disposition documents, etc. And then certain documents are specifically excluded from the scope of the Act. Obviously, wills and codicils are excluded. Real property deeds are excluded. Certificates of title for motor vehicles, watercraft, and aircraft are excluded. And then in the comments, states are given the option to add or subtract from that list because, for example, in the list is a community property survivorship agreement. Well, many states aren't community property and they wouldn't have that type of agreement, so they could remove it. Some states don't have body disposition documents, so that can be removed. Or maybe the state wants to add other documents to the list. So although there is a formulated definition, states can add or subtract documents from that list as they so desire. Now, one thing I do want to mention about the documents that is important, the Act is restricted to records that are readable as text. So you can't use oral or video recordings as documents. following the lead of the Uniform Electronic Wills Act, they all must be text-based types of documents.
So, Gerry, that's very helpful in your explanation of what non-testamentary estate planning documents are. One of the questions that I have had when I've been reading UEEPDA is that the definition is broad, but there are very specific things that are listed within the definition. And then at the end of the definition, there's a catch-all phrase that essentially says any other record that's intended to carry out an individual's intent would be included as a non-testamentary estate planning document. And I guess my question is, what were you guys thinking the scope of that catch-all provision would be?
So I'll take that one, Justin. I think our recollection of what the drafting committee intended was that last item in the laundry list of electronic estate planning documents, non-testamentary, was supposed to be a catch-all, and that the catch-all is intended to cover or capture any documents that aren't otherwise allowable under UEEPDA. So, for example, I've observed that beneficiary designations of retirement accounts and life insurance are being electronically signed more often than they're being signed in ink. And I'm sure that's because the companies who offer those contracts correctly view those beneficiary designations as a contract between the custodian of the account or the life insurer and the owner of the policy or the account holder. But there's probably a lot of documents we didn't list or that'll arise in the future that we didn't list, and the catch-all could pick those up. And then we felt that was a safe way to approach it, because then we have in the next section B, in this definition, we have a means for states to exclude documents they don't think should be covered. And our thought there's a whole world of those that really look like they're non-testamentary estate planning documents. Maybe they're titles to vehicles, maybe they're real property deeds that other regulators or other groups are going to want to cover separately and aren't going to want to have them fall under this law. And so that in our world, that's an enactment reason. We don't want too many people coming in interested in a bill. We want it to be cleaner. And we want estate planners talking about this and elder law attorneys. We don't necessarily want auto dealerships coming up and talking about this. So that's the idea behind how we drafted this.
I'm also really curious as to how, decisions generally get made in creating legislation and the process that goes on behind the scenes. Is there anything that you can share about working with the committee on UEEPDA that was really interesting, or stories that came up highlighting the need for modern signing options?
So, I don't recall people coming in and, I'll give you one example that I had in my head. I'm not sure the committee talked about it. And our clients are wealthy. This statute was drafted still when the pandemic was a little more active. And so I actually had a client who, jetted off to some island somewhere in the middle of a sale of a business and was still able to facilitate all the business sale document signing under UEEPDA. But also at the same time, as is often happens, there were estate planning documents being generated. And they happened to be more in the nature of trustee changes and administrative changes. And of course, then what the question was, well, okay, Susie, can you send me those via DocuSign? I'm here on this island isolating because I caught COVID when I was away. And I said, no, we've got to get you back here to sign them. So I think clients, business owners particularly, are used to electronically signing. And so we all, I think, on the committee recognize the need for this. And I've heard from a lot of practitioners who say, I didn't really think we needed to have a statute. We're already doing this. So I think there's a lot of reasons to do this.
So UEEPDA could have been drafted in a very detailed way that runs through specific circumstances for executing non-testamentary estate planning documents. Instead, there was an approach to draft it more broadly. For example, if a non-testamentary estate planning document requires a witness signature, then the signature can be electronic. If it requires notarization, the notarization can be electronic. Why did the committee decide to go in that direction with its drafting?
You're absolutely right. That was a conscious decision. We, Gerry and I, and the committee referred to it as the mini UEEPDA approach. We'll just take the provisions of the Uniform Electronic Transactions Act that we need to use here to facilitate electronic signing when we don't have a transaction, and we'll drop them into the statute. And Gerry did that quite capably. The only substantive decision or substantive provision that we included in the black letter of this law is one Gerry previously mentioned. We made a policy choice that the document had to be readable as text at the time it was signed. Now, that's an interesting policy choice because I happen to be serving on another drafting committee for the Uniform Healthcare Decisions Act update, and that committee doesn't like that. They don't want to be limited to documents readable as text. They want the new Healthcare Decisions Act to apply to oral declarations. So right away, we have a situation where another statute is going to take a different approach. So I think that validates the approach we took here. It's sort of the default approach. Let's make all the execution requirements the same if you want them to be electronic. And then we have the provision that basically says all of your underlying law applies to that document that already is there. So if you have a state that wants to enact what will end up being the new Healthcare Decisions Act and wants to recognize oral declarations or declarations that are dictated or recorded on a video, they could change that as to just those documents. And they could do that in their Healthcare Documents Act as opposed to in this statute. So my answer is, I think it's just a simpler approach. The simplest approach would have been one like Delaware's, where you're sort of bootstrap and you simply say, well, every document of this nature will be deemed to be a transaction under our cite to our state UEEPDA statute. And I don't think anyone ever thinks that that's the best way to draft a state law, but it is the quickest. And so I think states that have done that are going to then go back and take this more thorough approach where Gerry has drafted, and the committee has drafted a sort of mini UEEPDA where we took the provisions we think we needed and apply them directly.
Gerry, to oversimplify some of UEEPDA essentially provides that if a signature on a non-testamentary estate planning document is required, it may be in either ink or in electronic form. But one of the things that we as practitioners had to deal with during the pandemic was remote witnessing and physical presence of remote witnesses. Why didn't the committee dive into the physical presence requirement for witnesses and notaries and instead leave those decisions to the individual states?
The answer to your question, Justin, is real simple. We want the act to be able to be enacted quickly by as many states as possible. The people in different states have tremendously diverse views as to whether or not remote witnessing and even remote notarization should be allowed. And if we put a remote witnessing component into the act, I think it would have slowed up enactment. And so we decided that we are not going to require an enacting state to authorize the remote signing of witnesses if the validity of a document is dependent on having witnesses. But the act does have optional language. So if a state wants to make that decision that remote witnessing is to be allowed, that they can appear by electronic presence rather than being physically present, they're free to enact it. But again, like I said, we were afraid that putting in a remote witnessing component as a requirement would slow enactment. So that was the reason for why we did it.
I'm going to chime in and add one more thing, and that is that when we started our discussions with the drafting committee, we talked about this. Do we want to delve into these requirements? And initially, the committee said, no, just leave that alone. We don't need to cover that. And then at one of our last meetings, I proposed the inclusion of this optional section that allows states to expressly say, you can have remote witnessing if you want to. And I made that case, that's in section 207 of the Act, because I think if you're going to electronically sign, you have to recognize the possibility that folks don't want the witnesses in that room. And the ULC has this experience with its notarial law, the revised Uniform Law and Notarial Acts, where we did this initial step approach of allowing notarization of an electronic document, but the notary had to be present, and no one really does that. The whole point, especially, emphasized during the pandemic, is electronic signing facilitates remoteness in a time or a place where people don't necessarily want to be or aren't able to be in the same room. So I felt like we really had to include that. But as Gerry said, there are states like mine where we have a notable group of lawyers who are just concerned. They're concerned. They're unfamiliar with technology. And so it might take some time.
One of the problems that's arisen with electronic wills is retention of those electronic documents and who can act as custodian. Does it have to be an attorney, a nonprofit entity, a for-profit company, or does it have to be a government agency? And also, should that custodian be bonded? How does UEEPDA address the retention of non-testamentary estate planning documents that are executed electronically? And what are the requirements about who can hold and retain that document?
So, Ross, that's a great question. And the answer is it doesn't. And it doesn't address those requirements deliberately for a couple of reasons. Number one, the ULC has had a positive result drafting Uniform Electronic Transactions Act to be less prescriptive of technology. And that act has been in place for a long time without the need for an update because of updates in technology. Number two, we looked at the sort of existing drafting models for electronic wills when we started drafting that act, and a lot of them included some prescriptive custodian requirements. There had been a previous law enacted in Nevada, which was very prescriptive of the technology that had to be employed, which no one used. So we had this history of overprescribing equals, disuse. No one's going to do that. And so then we had this decision in the Uniform Electronic Wills Act not to prescribe, not to address custodians. Why do we think that was the right result? Essentially, what we're doing is we're leaving that to market forces, right? We're leaving Susie Walsh, trust and estates practitioner, to make the case to a client that I ought to be the custodian of their electronic will if I want to do that, or their electronic estate planning document. As a practical matter, most of these documents, I have some of them in my file, right? I use a electronic document signing platform. I rely on that platform to encrypt the document, make it safe, perhaps to store it. I then have a means of storing it and keeping it safe within my workspace, let's call it here. And so we would call that leaving it to market forces. If a client wants to electronically sign and doesn't kick the tires on the lawyer who's representing them and maybe isn't sure about how things are being encrypted or saved, well, that may not be the right choice. But in this day and age of pretty easy encryption and safe storage, I think it will work. Last point I'll make is we all recognize the benefit of centralized storage in a state of wills. And, a central registry of wills, is everyone loves that idea. And that was one of the sales pitches we thought we would make with the Uniform Electronic Wills Act, to practitioners. You may hate this idea, but you can get rid of your wills vault, which is sort of the bane of existence of every practitioner. You've got these 80-year-old wills and nobody's claimed them, and what do you do with them? And it's a big mess. And so folks would love to offload that problem. And in Florida, I believe they spoke to the circuit court clerks who were going to offer a storage repository. In Nevada, I think it was the Secretary of State. They were going to offer a storage repository. And that's all a much more feasible thing with electronic documents than it is with paper. We don't want folks resorting to limestone caves like the IRS. So you're right. It's not in there, but it's not in there deliberately. And we thought that was the right way to go.
Do you guys see states going with whatever they have decided for wills with the non-testamentary estate planning documents? So, for example, if there's a state that has specific requirements as to how electronic wills should be stored or who may store them, do you think that when they're adopting UEEPDA, they will go with that same type of storage requirement? Or do you think that these are different documents, right? Wills are so sacrosanct, right? There's a process for executing them and storing them. You only have one original. And so do you think there's a difference between the significance of wills versus non-testamentary estate planning documents that will translate into custodianship?
So it could. I mean, a lot of these documents we all have in our files now, right? All the trustee resignations and the trustee appointments and all of this administrative stuff you do, all of it's being done electronically, frankly, now anyway, or at least it's stored electronically. So I suppose it would be reasonable to think that a state bar and an enactment group might say, we're not going to get all caught up in who's the custodian of this because we don't have any rules on that now. And I'm always amused by our view of wills as being, which we adopted, right? In the ULC, we did a separate law for electronic wills. That's just the view. They're sort of this sacrosanct creation. In my state, they're not. You know, we don't use wills. That's not the primary driver of an estate plan. It's a funded revocable trust. But I do understand that there are states where, and Gerry, is Texas one of them? Are you still a big will probate state? And so I would expect, Justin, you get this reaction when you go up to the legislatures from the fewer legislators who are lawyers. Well, I took a whole class on this in law school. I had Professor Beyer teach me how important a will is. Don't you tell me that the storage requirements aren't important. So, you know, we'll have to see. But I do think that's a natural reaction that folks have. Wills are more important. Everything else is less.
If you had a crystal ball, where would you predict we'll be in 20 years as an industry with estate planning documents and signings and probate processes? I mean, definitely won't hold you to this, but I'm just curious as to where you think we're going and where we'll be in 20 years.
I think in the future that we will move continuously into more electronic documents. And you asked me to predict what I would like to see happen in 20 years. Well, I'd like to see one estate planning document where it is a will, it's a trust, it's a power of attorney, it's a financial power of attorney, healthcare, body disposition, the whole thing in one document rather than having 7 or 8 documents. And I know in my state, the execution requirements are all different. Some need witnesses, some need notarization, some need notarization and witnesses, some need notarization or witnesses. They're all different. So they have one, estate planning document and then have everything together, all electronic, is what I'd like to see happen in 20 years.
One ring that controls them all, right?
There you go.
Susie, any thoughts?
I've given up trying to predict behavior, but certainly I see more and more demand for these services. I get very grumpy when I'm acting as trustee and I'm dealing with a financial institution that can't send me stuff, the garden variety stuff I have to sign, authorizing a distribution, authorizing whatever. I get pretty grumpy when I can't e-sign it because it's so much easier for me to do that. And it's something I can just take care of whether or not I'm in my office, if I'm away. So I think more people are like that. They're going to expect this.
There is one significant difference between UEEPDA and this act, and that is that the signer does not need to specifically indicate consent to electronic signature, because under UEEPDA, before you sign it electronically, you have to check a little box or do something to acknowledge that you are going to allow it to be signed electronically. But for a unilateral document, it is obvious that the signer is consenting to using electronic signature because the person is using electronic signature. So that requirement of UEEPDA was not placed into this act.
I completely agree with that. And as a drafts person, I'm always concerned about whether documents that I draft and clients sign are going to be valid in other jurisdictions if my client relocates. So under UEEPDA, what happens if someone signs electronic non-testamentary estate planning documents in a jurisdiction that has UEEPDA, but then they move to a jurisdiction that it's not recognized? I mean, what do you think? Is the document and the signature still valid?
The answer to that question is going to depend upon that new state, the state that they move to, what type of saving statute they have with regard to giving validity to documents that are valid in other states. Almost all states have a statute for wills that says if the will is valid in the state where executed, it will be valid in our state, even if it doesn't meet our state's requirements. A common example would be in Texas, we can have a handwritten will without witnesses, and it is valid. Take it to another state where all wills have to be witnessed, they might have a saving statute that would validate it. It gets interesting with electronic wills because there are a few states that will not recognize an electronic will, even though it's valid in the state where executed. They've said our policy is no. So it's going to depend upon what states have with regard to their own statutes giving validity to documents executed in other states, which already exists because it already exists with regard to paper documents. So it should also exist with regard to electronic documents unless the state has decided to exclude an electronic document from its saving statute.
Susie, UEEPDA provides for the inclusion of the Uniform Electronic Wills Act in Article 3. Do you see any situation where a state would adopt UEEPDA, but then doesn't adopt some version of the Uniform Electronic Wills Act?
I do. That hasn't occurred yet, but I do see it in here. And it really is, I thought of it because I'm in Connecticut, where we have this resistance to new technology within our bar, very entrenched. So I had actually talked to our current chair of our subject matter section, and he very much wanted to go ahead with both. And I suggested, well, if you encounter this resistance, go ahead with UEEPDA first, because again, we talked about this, how people have this view that wills are sort of sacrosanct and special somehow. So lead with the documents that people are less concerned with. Lead with your garden variety trustee change, or all of the documents facilitating trust certification and that kind of thing that no one really worries about. The ones I think practitioners tend to obsess over are wills and to some extent powers of attorney. But the powers of attorney is an easy conversation to have with your elder law bar and sort of reassure them that the world isn't going to end and it's all going to be fine. So that's what I envision, that enactment will be more robust with UEEPDA and will lead to the enactment of the Uniform Electronic Wills Act after the sky hasn't fallen. But I am seeing in Connecticut that even that approach, you still have this, the sky is falling, the Chicken Littles all come out. And we're just going to all have to work through that and be reassuring. And frankly, I think the biggest driver for this is going to be clients. If you're getting enough enraged calls from your clients who are upset that you can't offer them electronic signing, you're going to be more supportive of this legislation and less resistant to it. That's what I think.
Some states have adopted the Uniform Electronic Wills Act as crafted by the ULC, and some states have made substantial changes to that Uniform Act when they pass their own legislation. What do you see happening with UEEPDA? Do you think that states will lean more towards adopting it as is, or do you see it as more of a starting point for states to create their own legislation?
I think that it will be enacted pretty much as is. Unlike the other acts, which there's more what I would call debate upon the terms. This is a pretty simple act to just authorize electronic signatures where a lot of people already thought they could do it. So the hope is they'll enact it as is. About the only change they'll make is maybe adding or subtracting documents from the definition of a non-testamentary estate planning document that we talked about earlier. So I anticipate it will be enacted in very uniform form. That's my hope, and that was our intent. Other things like the remote witnessing, remote notarization, electronic wills, all of that can be added separately if a state so desires. The hope is that because of the need for this that was brought home during the pandemic, we're hoping that states will just enact it as is quickly to allow the electronic signing, which, as both Susie and I have discussed many times before, many lawyers already think can be done, and there is an extreme client demand for being able to do it electronically.
Sometimes when uniform laws are created, there are many states that are quick to jump onto the train, and they quickly pass the version that was passed by the ULC. Have you guys heard of any states that are looking into adopting UEEPDA quickly, or what kind of feedback have you guys heard?
So I know, for example, in my state, our state bar, as I mentioned, was really eager to get this off the ground. But unfortunately, in some states, the Trust and Estates Bar, like New Hampshire, it used to be like this, they pretty much could just send things off to the legislature and they would be enacted ipso facto presto, as Attorney Berry likes to say. In other states, no matter what you do, you run into a problem. So we don't have, unfortunately, I wish we did, we don't have a crystal ball. I do know there's interest. I do know, for example, in Connecticut, there's a bill being drafted and which they hope to have raised. I think we will know better in a couple of months as legislative sessions start to ramp up. And don't forget, in some states, it's in every other year. Usually there's quite a variation in the schedule. So I think I hate to say this, but we don't know that right now. We'll know better soon. But what I can tell you from experience is this is, to me, an easy bill. It's one subject, it's short, it's easy to explain. And I challenge you to find anybody and at a legislature who hasn't had to e-sign something. So they understand it. So for that reason, I would like to think this would be easy for state bars or state commissioners to run up the flagpole, as we say.
This has been a fantastic conversation and really eye-opening and interesting. If our listeners want to hear more or learn more about UEEPDA potentially coming to their state, how can they learn more?
Well, thanks, Jennifer. There are lots of resources available that the Chicago office of the Uniform Law Commission produces, things like quick summaries of the act and an enactment kit that they produce. You don't even have to remember any of that. If you can remember my name, you can look me up online, and I will put you in touch with the appropriate person at the ULC or provide you with things like PowerPoints to use to your state bar or explanations, or we're always available just to answer the phone. And then the support that the ULC provides can be very sort of detailed and granular, such as I'm trotting up to my public hearing at the legislature to try and have this enacted for you folks. Can you help me with the testimony? Whatever you need, we will try to provide it. So just let us know.
Fantastic. Many, many, many thanks to our esteemed guests, Susie and Gerry, today. It was an honor to have you on the podcast, and we greatly value your time and expertise. It will really be interesting to see how this develops. And on behalf of Justin, Ross, and myself, thank you for listening to the Digital Planning Podcast. Please feel free to reach out to us with any questions. You can find us at digitalplanningpodcast@gmail.com. And if you have an idea for a show topic, we'd love to hear it. So we'd love to hear from you. And until next time, thank you and be well.
Thank you for listening to this episode of the Digital Planning Podcast, the podcast designed to educate individuals about all things digital in connection with estate planning, business planning, and estate and trust administration. Please subscribe to this podcast and leave us a rating or review on iTunes, Stitcher, Google Play, Spotify, or wherever you download your podcasts. Thanks for joining us. We'll see you next time.